Hey everybody, today we're going to talk about marriage. There's a lot of things we're not going to talk about marriage, but as it turns out, when it comes to estate planning, whether you're in a married or an unmarried relationship makes a lot of difference. So let's get started. A friend of mine, who frequently inspires my writing topics, asked me if I thought people were happier married or unmarried. I assumed the question meant in a married relationship or no relationship, but I suppose it could just as easily mean in either a married or an unmarried relationship. While I have no interest in advising people whether to pursue a relationship or not, I do want to broach the subject of how different being in one type of relationship versus the other could affect you financially and legally. There will be some noticeable differences during the course of your life, but the greatest disparity comes if the relationship ends or one of the partners die. From an estate perspective, having a well-constructed plan in place with proper legal documents could resolve any issue in either type of relationship. But absent these documents, few would be happy with the defaults. Despite the entrenched romantic or religious views of marriage, still basically a legal contract managed by the government. As cold as that sounds, it can actually be beneficial. Marriage is technically a partnership that involves every aspect of people's lives, so states have created specific statutes to help manage the details of those arrangements should differences arise. In other words, you have to get the state to approve entering a marriage contract, and you have to get the state's permission to end a marriage contract. For the past few decades, we've heard a lot about same-sex marriage. Before laws changed, states would not approve a contract for two people of the same sex to enter into a marriage partnership. Most of the objections centered around the religious view of what a marriage represents, but when you come down to it, there's nothing romantic, religious, or idealistic about a contract. For all of history, couples have shown that the romantic aspects of a relationship do not need the approval of the state in order to be real for those two people. It is the other rights endowed by the contract which do make a logistical difference. There is an increasing number of heterosexual relationships that choose to forego the formality of marriage, and it seems that the number of same-sex relationships pursuing marriage is on the rise. Whatever motivates these changes, from an estate planning perspective, there are significant considerations for either type of a relationship. Since unmarried couples typically have no written agreement, they are the most vulnerable when things go sour between them. And during the relationship, there are missing financial and personal benefits bestowed upon those who sought formal approval from the state. Two people willing to pledge their troth are usually entering with a positive frame of mind. On the other end, it can become quite a different scenario. It illustrates how insufficient the state contract is. In a divorce, the fine details of the marriage contract must be interpreted and weighed against the expectations and demands of each party. A divorce becomes a negotiated settlement, where the attorneys, the individuals, and the courts use various means to come to an agreement how the dissolution of that contract will end. Other than bliss, the living benefits of marriage are some tax advantages and rights of access. HIPAA laws have made it difficult for anyone other than a spouse to be able to receive full access to the private medical information of their partner. This gap is easily remedied with a well-written healthcare power of attorney and any other related documents an attorney recommends in your state. But only the healthcare power of attorney can grant people other than spouses those same rights. Even a parent of an 18-year-old is not legally entitled to that access without this document. For the unmarried couple, there is nothing automatic in how your financial affairs are handled in the event of the relationship terminating or if one of them were to die. Verbal agreements have no bearing. especially when the parties disagree on what was agreed upon. Even if some arrangement existed where both parties contributed financially, property with title or deed will remain the property of that person after the relationship ends, or will be transferred at death according to their will or trust documents. Only joint accounts and property with both names will be divided between both parties. For personal property similar to marriage, pre-owned things remain the personal property of that individual, and things acquired solely by one party during the relationship is deemed to be their personal property when it ends. When money's commingled and personal property is purchased jointly, that becomes joint property up for division at the end of the road. With no set laws to govern, this could be a tricky element to enforce, and without cooperation, may require legal action. While you can simply walk away from such an undocumented relationship if you want to, dividing property can become even more complicated than in a marriage situation, especially if the couple have been together for a long time. The structure of marriage works well for any couple who intends to become life partners. Even if it doesn't work out, at least there is some framework to fall back upon. But neither option precludes the need to do estate planning and make all the choices and decisions using documents in the correct legal format. Marriages later in life, where individuals have children and assets from before this new union, complicate matters even further. It's foolish to assume that things will turn out like you want without proper legal documentation. The other positive thing about doing this planning is that it requires couples to discuss these issues openly with each other, which could actually help the relationship. People who avoid talking about such things may never fully understand what their partner is thinking. A good estate planning consultant will not make choices and decisions for you. They will make sure you understand the consequences of your choices, so that you're fully informed how your heirs and beneficiaries will react to the way you address them in your plan. Like most plans, hope for the best, but prepare for the unexpected. No matter what the future holds for you and your significant other, you need to be properly prepared. You only get one life. Make the most of it with a good plan that covers all contingencies.